Welcome back to the SLIS Professional Development webinar series. I'm Dr. Ed Benoit, I'm the Associate Director of the School of Library and Information Science. And I believe this is our third in the series. Just like before, a few housekeeping notes before we get started. Please use the chat area to post any technical difficulty questions, and use the Q&A area to post any questions for the speaker for the end of the webinar. Finally, there will be a short 5-minute break halfway through the webinar. And I would now like to, that's me anyway, introduce our speaker, Mr. Benson Green. Mr. Green is a trial consultant specializing in high-stakes intellectual property litigation, whose primary focus is on patent litigation in the pharmaceutical, medical device, computing, and cell phone industries. In addition to his extensive patent litigation experience, Benson has worked on copyright and trademark litigation across a wide variety of industries, including food and beverage, hospitality, and automotive manufacturing, as well as cases involving the fine arts, film, and tabletop gaming. Benson has also provided thousands of hours of pro bono services to artists in partnership with organizations such as Lawyers for the Creative Arts, which provide legal services to creators who may not be in a position to afford market rate legal services. So please join me in a big virtual round of applause in welcoming our speaker, Mr. Benson Green. And I hand it over to him for screen sharing.
Great. All right, so everybody should be able to see my screen, which has my slide deck and also me available. So thanks for the introduction, and I forgot I wrote that blurb for you. So there goes like the first page of my presentation. So just to give you a little bit more background about who I am and why I know so much about copyright law. So first of all, as Ed said, I'm a trial consultant. So importantly, that means I did not go to law school. I don't have a law degree. I'm not admitted to the bar anywhere. And so, of course, nothing I say should be taken as any form of legal advice. So I want to get that out of the way. I have to say that at the beginning, so you don't get me in trouble later, because I'm not a lawyer. All right. So. But what is trial consulting, and why do I know so much about copyright law? Well, simply put, trial consultants help to prepare cases for trial. Now that may seem a bit redundant, but a funny thing happens, I like to say, when lawyers go to law school. They stop thinking like regular people and they start thinking like lawyers. And my job, simply put, is to help lawyers remember to think like a regular person, how to communicate with a regular person. So I specialize in understanding how people process information, make decisions, and behave as a group, which is important because we deal a lot with juries. And one of the ways that I do that is by conducting small group research projects, such as focus groups or mock trials, to see how jurors might react to the facts of a case and various legal arguments. I help lawyers pick juries, which is what you might be thinking trial consultants do mostly. I do that, but the more important part of my job is developing overall case strategy, including identifying key trial themes, helping prepare witnesses for their testimony, and drafting opening statements and closing arguments. So that's the real meat of what I do. And then on top of that, we also pick juries and do a variety of other things with regard to trials, help with demonstratives, that kind of thing. Basically, what all that means is I get to do all the fun, cool stuff that happens at trial and not all the boring paperwork on the back end. So that's why it's fun to be a trial consultant. Now, in order to do my job, I have to know how jurors are likely to react to certain legal arguments. But more importantly than that, I have to know what legal arguments can be made given the facts of the case. And for that, I have to know a whole lot about the relevant law what the relevant law is and how it works. So this means I have a lot of practical, hands-on experience with the law that partly comes from asking lawyers a bunch of annoying questions about what they can and can't say in the courtroom. So that's primarily how I know what I do about the law of the cases that I've worked on, primarily intellectual property litigation. So in terms of my experience, as Ed said, I'm almost exclusively in the area of intellectual property litigation, primarily in patent litigation. I also do some stuff in contracts, torts, employment law, and so forth. But the bulk of my experience is in patent litigation because that's frankly where the money is when it comes to high stakes litigation. There's a lot of patent cases filed. There's a lot of money at risk in these patent cases. And so that's when you hire a trial consultant to be involved, because you're paying your lawyers, and now you have to pay a consultant to come in and assist your lawyers. That only happens on cases with a large amount of exposure. So as we will learn in this webinar, one of the reasons why I have not worked on as many copyright cases and trademark cases as patent cases is because these cases are much less likely to see the inside of a courtroom. What I mean is, like, they're much less likely to actually go to trial and be tried in front of a jury. Copyrighted cases in particular are very rarely tried to verdicts, and if you aren't going to be in front of a jury, you probably don't want to hire someone like me to help you out, right? On the one hand, copyright cases are inherently unpredictable because the factual decisions that the law requires you to make are very highly subjective. So it's hard to predict what people are going to do with it. And on the other hand, because the facts are very subjective, judges are rarely willing to dismiss a copyright infringement case. So normally a judge might dismiss a case if the judge says no reasonable finder of fact could come to any decision other than in favor of this party, so I'm dismissing the case. Because copyright cases are so subjective, judges are rarely willing to go as far as dismissing the case, and so they usually wind up in front of a jury, and then you don't know what the jury is likely to do. So a lot of people don't want to take the risk of taking a copyright case to trial. Another reason copyright cases might not go to trial is because there's not a lot of money involved in copyright cases. A lot of times damages are pretty limited, and a lot of the relief is equitable, which means you might be required to turn over infringing copies or to destroy the means of manufacturing infringing copies, but you're not going to be paying a lot in terms of actual monetary damages. So there's not a lot of people who file copyright infringement cases as sort of speculatively in the way that they would file patent cases to try to make some money off of a big company like Intel or Microsoft or Apple. So the other reason why copyright cases don't go to trial a lot is because the injured parties are often starving artists, and they can't either hire a lawyer, or it's not worth it to them to hire a lawyer to try to protect their artwork. So as Ed said, a lot of my copyright experience comes from pro bono work through organizations like Lawyers for the Creative Arts, which means that while I don't get paid for my work on copyright cases, I am usually involved very early in the process. Sometimes before the clients even have formal legal counsel. And I tend to work very closely with the lawyers throughout the entire process. As you might expect, this means I'm very passionate about copyright law, and I've put a lot of hours into it. I think it's about 5,000 or 6,000 hours. Because I do a lot of pro bono work, I don't always keep track of my hours, right? Because I'm not sending out any bills. But I put about 5,000 or 6,000 hours into copyright cases over the years, involving everything from fine art, toy soldiers, board game, independent films, Pepe the Frog, cartoons. I've been involved in multiple copyright infringement cases that have been tried to verdict, and involving hundreds of different copyright infringement claims. So I actually have a pretty decent amount of experience, even when it comes to lawyers, about taking copyright cases to trial and how the process works from that point. All right, so why don't we start by taking a look at what a copyright actually is. And I'm going to do my best to not talk too quickly. Somebody just, if Ed can let me know, or somebody can let me know if I'm going too fast. I write opening statements, but I don't actually give them. So I can talk a little fast. All right, so copyright basics. First of all, we should bear in mind that when we're talking about copyrights, what we're actually talking about here is the United States Copyright Act of 1976, which along with a variety of subsequent amendments is codified in Title 17 of the United States Code. So if you hear me saying something like US 17102B or something like that, that means I'm referring to the actual written laws that come from the Copyright Act of 1976, because that's basically how our law, how United States copyright law works right now. So another thing about copyright is that it's understood to be a type of intellectual property, and the other two common types of intellectual property are patents and trademarks. So it's worth it. It's worth it right now, before we start digging into what a copyright is, to talk a little bit about how copyrights are different from other types of intellectual property, particularly from trademarks, because I find in my experience working on cases and doing research on copyright cases that people are often will often confuse copyrights and trademarks. So I think it's important to take a look at the distinctions between those various forms of intellectual property. So as we can see here, a patent provides exclusive rights to an invention, which means it is a device or method that serves a useful function. A copyright, in contrast, provides exclusive rights to a work of art, which is specifically and importantly something that serves no useful function. So in fact, things that have a useful function are carved out of copyright protection. So you can't actually protect something that has a utilitarian function with a copyright. So patents and copyrights are like two sides of the same coin. They both provide exclusive rights to a different kind of thing. Patents for useful articles, copyright for things that have no intrinsic utilitarian value. So they're just about art. Trademarks, by contrast, came out of Truman era antitrust litigation. So they're actually more about protecting consumers than about granting exclusive rights. And indeed, you could say that trademarks are intended to prevent monopolies, whereas patents and copyrights are intended to create monopolies, little monopolies, but they're intended to create little monopolies. A point of a trademark is to mark a good for trade so that consumers are able to identify the source of a good or service. In this way, trademarks are about preventing consumer confusion. And in fact, pretty much the only way to prove trademark infringement is to show that there is a likelihood that consumers will be confused. In other words, that the mark will potentially harm consumers by hampering their ability to know what they are buying and who they are buying it from, which is very different conceptually from the genesis of patents and trademarks, which actually come out of the same article in the United States Constitution. So unlike trademarks, patents and copyrights are based in the United States Constitution, whereas trademarks come out of Truman era antitrust litigation. So now that we know a little bit about how copyrights are different from trademarks, we should take a look at why copyright laws exist in the first place. So why are they there? What benefit does copyright protection give to our society, which is why it would be in the Constitution and in a lot of our laws. I find that when trying to understand how a law works, it really helps to keep in mind why the law exists in the first place. What purpose is it intending to serve? Just the other day, for example, I was reading about the progress of Trump's election lawsuits. And in one of those hearings, I think in one of the Pennsylvania cases, the presiding judge actually said that election laws are intended to enfranchise voters, not to disenfranchise them. And so interpreting the laws that are intended to enfranchise voters in a way that would lead to the disenfranchisement of voters or promote the disenfranchisement of voters was contrary to the purpose of the law, right? And so our laws really are based in that way. They really are equitable in that way. So it's important to understand why we have copyright laws and the purpose they're intended to serve, because all the various interpretations of Title 17 are going to circle back to that primary purpose of copyright law. At its most basic level, copyrights are intended to promote artistic expression. That is, the creation of art, in whatever form it takes, is recognized as an important part of human culture and a valuable contribution to our society. So in other words, we want more artists to make more art. And copyright is intended to encourage the creation of artistic works in the same way that patents are intended to encourage the creation of new and useful devices and methods to increase the progress of science. And Article 1, Section 8 of the United States Constitution provides the basis of both copyrights and trademarks. So copyrights and patents. So Article 1, Section 8 says, Congress is empowered to promote the progress of science and the useful arts by securing for limited times to authors and inventors the exclusive rights to their respective writings and discoveries. In other words, copyright promotes the creation of artistic expression by doing two things. First, giving artists exclusive rights to their artistic expressions helps to ensure that artists are able to profit from creating art. So why would you create a work of art? I mean, there's reasons why, but from a practical perspective, why would you create a work of art if someone can just take it, copy it, and compete with you in the market for that work, right? To make it hard for me to make any money off it. Second, limiting the duration of exclusivity, because remember, copyright is limited. Because Congress says for a limited period of time, you should have these exclusive rights. So limiting that duration both encourages artists to make new works of art in the expectation that the value of a work will decrease after exclusivity expires. And also, and more importantly, it allows artists to build upon the work of others after their exclusive rights have expired. Artistic expression thrives on inspiration, adaptation, recasting, repurposing, reusing, and reimagining the works of other artists. And so limiting the duration of exclusivity is an important part of copyright law. For example, the British Library, which I really like the British Library, I use their stuff all the time. The British Library has released millions of digital materials to the public domain and has explicitly done so for the purpose of allowing artists to reuse those works. So this is a quote from their Flickr Commons website, which to say the British Library's collection on Flickr Commons offers access to millions of public domain images, which we encourage you to explore and reuse. The release of these collections to the public domain represent the library's desire to improve knowledge of and about them, and this is my emphasis, to enable novel and unexpected ways of using them, and to begin working with researchers to explore and interpret large-scale digital collections. So in other words, creating art is about reusing and reworking and reimagining the works of other artists. And so that's why a limited period of exclusivity is important, as an important part of copyright law. What we will learn, however, through this webinar is that the tension between adequately protecting the unique work of an individual artist on the one hand, while at the same time leaving room for other artists to create their own unique works of art, is a defining characteristic of copyright law. There's sort of an inherent tension in those two goals, protecting one artist's work while allowing room for other artists to make their own works of art, because you don't want to restrict the creation of new works of art by providing overbroad protection. In other words, although exclusive rights are necessary to protect and therefore encourage expression, the power of exclusivity itself is just as apt to restrict those opportunities. So the salient question in copyright law and its interpretation and application, therefore, is where does copyright protection begin and where does it end? So where does protection start and where does it stop? So as you know, most of my personal experience with copyrights is in the area of adversarial litigation. So I'm going to talk a whole lot today about how the scope of a copyright is defined, because that's very important when it comes to accusing someone of infringement. What are the boundaries of your property, and have I crossed over those boundaries? In other words, what do you actually own when you have a copyright? But we should take a moment before we talk about the scope of a copyright to talk about duration, right? How long does copyright protection last, assuming you have something to protect? The question is most important with respect to the public domain. Remember, the British Library here is talking about the public domain. And the public domain is works for which the period of exclusivity has expired and which therefore are free for public use. That constitutes essentially the public domain. Now, you can specifically inject works into the public domain, but it actually takes a deliberate act. You have to give up your rights to it proactively. But nevertheless, the public domain basically means things that for which protection has expired and are free for anyone to use. Now, it turns out, of course, that as with most things related to copyrights, as we'll find, this is a very complicated question, thanks to a variety of different national laws. So different countries have the different different copyright laws, slightly different. And more importantly, the ways in which those laws have been adapted, updated, and changed over the years. But there are at least a few pretty reliable rules of thumb that we'll talk about in terms of what's in the public domain and how long copyright protection should last and is expected to last. We don't need to go into exactly what those rules are yet, but in general, the duration of copyright exclusivity has been legislatively expanded over the course of United States history. So let's take a look at a quick chart here that shows us what copyright duration, how copyright duration has expanded. So currently, right now, copyright lasts from the death of the author plus some number of years, or 95 or 125 years as a fixed duration if it's a work for hire. So like if Disney hires somebody to write a screenplay, that work is owned by Disney and it has a shorter period of exclusivity, depending on how long the author lives and whatnot. So in short, copyright protection in the United States originally lasted about as long as patent protection. Patent protection lasts about 20 years, and originally copyright was intended to be almost exactly the same in terms of its exclusivity as patent protection, 20 years. With the Copyright Act of 1976, the US brought its copyright duration more in line with that of other countries, which rather than a fixed term tended to use the life of the author plus about 70 years, give or take. The 1998 Act, as we can see here, also referred to as the Mickey Mouse Protection Act, extended that duration a little bit longer. But here are some rules of thumb, and we don't need to go into these in a whole lot of detail. But copyright protection lasts a good long time, essentially, in this country. But if you're talking about anything that was published before 1923, it is in the public domain as far as the United States is considered. So that's a hard cutoff. If it's pre-1923, it's in the public domain. It should be free to use. If it was published anywhere up through the 60s or 70s, odds are pretty good that the copyright has expired, because as you can see, if you take a look at this little cheat sheet here, if it exists prior to 1976, you would have to have extended the copyright and filed like 3 or 4 extensions. And so a lot of times, if it wasn't a commercially viable work, those copyright extensions haven't been filed, and there's a lot of orphan work. So if it was if it's from the 60s or 70s, it's a good bet it's already in the public domain, but someone might have extended the copyright and might have maintained registration, and it might still be protected. So with all that out of the way, let's take a look at what copyright actually is at its most basic level. So what do you own when you have a copyright? So first, let's take a look at the word itself. So we have copyright, which is copy, right. The right to prevent others from copying. Okay? That's what a copyright is at its most basic level. But to get more specific, let's take a look at the list of exclusive rights that the law grants to the holder of a copyright, because Title 17 will grant a list of exclusive rights that you have if you hold a copyright. There are important limitations to those rights, and we'll discuss those in a bit. But for now, let's take a look at what Title 17 actually says. All right, so it's very complicated here on the left-hand side. It's very wordy, and I'll read through it pretty quick. Subject to sections 107 through 122, the owner of a copyright under this title has the exclusive rights to do and to authorize any of the following: to reproduce the copyrighted work in copies or phonograph records, to prepare derivative works, to distribute copies to the public by sale or transfer of ownership by rental, lease, or lending. In the case of literary, musical, dramatical, and choreographed works, you can perform them. In the case of literary, musical, dramatic, choreographical works, etc., to display the work publicly. And in the case of sound recordings, to perform the copyrighted work publicly by means of digital audio transmission. All right. But what that boils down to is the rights that you have are to reproduce, distribute, display, and perform, right? In other words, you have the exclusive right to make a copy of your work and to control if and how the work is distributed and consumed, which are basically the ways an artist might make money off of work. Because remember, that's the core principle behind copyright law. You want to encourage artists to make art by giving them a financial incentive to do it. And so protecting the ability of an artist to make money off of work of art is important. So what copyright law over here is giving you are the exclusive rights essentially to make money off your work. Reproduce it, which means you can make copies of it and sell it. So you can make a copy of a book, sell it to somebody. To distribute the work or copies thereof. To display it, if you're going to show it like in a movie theater, or if you're going to hang a picture in a gallery, and to perform it if it's a performative work. Okay, so it's important to note here that a copyright holder also has the exclusive right to prepare derivative works. I kind of glossed over that, but number 2 is to prepare derivative works based on the copyrighted work. We're going to discuss derivative works in more detail, but the concept of a derivative work is pretty complicated. And I find that it helps to understand the scope of a copyright and what a copyright is before you take a look at what a derivative work is. We're going to table derivative works now and come back to it in a bit. Okay, so if copyright law prevents copying, what does it prevent copying of? Okay, so let's take a look at section 102A. Copyright protection subsists in accordance with this title in original works of authorship fixed in a tangible medium of expression, now known or later developed, from which they can be perceived, reproduced, or otherwise communicated either directly or with the aid of a machine or device. Works of authorship include the following categories, and there's a variety of categories: literary works, musical works, dramatic works, pictorial, graphic, sculptural works, motion pictures, sound recordings, architecture. But the important points in section 102A are original, fixed, and tangible. Those are really important. We're going to learn a lot about why those are very important. In order to be protectable, a work must be an original work of authorship fixed in a tangible medium of expression. In other words, if it is itself a copy of something someone else did, or even of something in the public domain, which is something someone else did, even if it's not subject to its own exclusivity, if it's a copy of something in the public domain, it isn't protectable because it has to be original. And that's compared to from the date you create the work to everything else that has ever existed in human history. So it has to be original compared to everything else. And to the extent that an element of a work is not original, it is also not protectable. That element itself is not considered to be protectable. Further, concepts and ideas are not protected by copyright. So we're going to take a look now at section 102B of the US Copyright Code, which comes right after this. In no case does copyright protection for an original work of authorship extend to any idea, procedure, process, system, method of operation, concept, principle, or discovery, regardless of the form in which it is described, explained, illustrated, or embodied in such work. In no case, to any, regardless. It's very, very strong language right there in black letter in Title 17. Now, the reason why that language is strong is because this section partly defines what a copyright is in relation to patents, right? Because a patent would protect a process, a procedure, a system, a method of operation, right? Those are things that a patent would protect. But importantly, copyrights also do not protect ideas or concepts, which is where a lot of the controversy in copyright litigation comes from. When is it an idea or a concept versus when is it something that is fixed in a tangible medium of expression? Okay, so these limitations exist, as I said, because overly broad copyright protection, just like overly broad patent protection or trademark protection, perverts the very purpose of the laws. So if copyright protection covers an idea, it restricts the creation of new works of art, because an idea is not a physical expression of art. It's not a work of art, right? And artists should be allowed to have access to the intangible realm of ideas. If patent protection is overly broad, just like copyright protection, it prevents others from building upon existing technology. So in other words, as I like to say, intellectual property is not intellectual because it only exists in your mind. It is intellectual because it is the product of your intellect. It is something that you create. It is not what you wish or imagine or desire or what somebody else has already done. It is unique to you, and it's something that you actually create. Your own ideas doubtless owe much to the work of other authors that came before you, and so you, like any author, are well entitled to borrow from, take ideas from, and be inspired by the work of others. What the law says you can't do is copy someone else. Copying in this context is specifically relegated to the realm of works fixed in a tangible medium of expression. Okay, as subjective as copyright law can be, and we'll find out just how subjective it can be, it needs some semblance of a concrete basis. That concrete basis, which is enumerated in the code itself, is tangible expression. Okay, so copyright remains grounded by being very specifically limited to the realm of things, and specifically excluding the intangible realm of ideas. It may be called intellectual property because the idea was formed in your mind, but the only way to measure that idea and compare it to others is in terms of how you fix that idea in a specific expression in a tangible medium. You effectively freeze it in time as a self-contained artifact and gain limited exclusive rights to prevent others from reproducing it. Okay, so now that we have an idea about what copyright is and what exclusive rights it gives you, let's take a look at how you get a copyright. Importantly, copyright exists to the extent that a work is protectable as soon as a work is fixed in a tangible medium of expression. Copyright is an inherent right in this way. It is not something you have to apply for. Like for a patent, you have to apply for a patent, it has to be granted. A copyright exists as soon as you fix it in a tangible medium. It's copyrighted. Now, you can register it, but registration does not itself create a copyright, nor does a lack of registration undermine a copyright. And because it's an inherent right in the United States, copyright is one that is a right that an author must specifically give up, like I said before, if you intend to do so. In other words, as soon as you make a work, you're entitled to copyright protection. The work has to be original in order to be protected, and is, in simple terms, only protected to the extent that it is original. Right? That's how copyright works. Your work is only protected to the extent that it is your own unique expression. The same rule, of course, applies to all works of art. So date of creation becomes very significant in copyright law. If I create a work before you, your work must be distinct from mine in order to avoid infringing my work, in order to avoid being a copy of it. Well, technically, you have to have access in order for. I dropped a section about access. You have to have access in order to make a copy. Access is almost a given in any copyright infringement case. The only point about access is that copyright protects against copying, and you can't create a copy unless you have the thing, the original, to make a copy from it. So in theory, two people could independently create the exact same thing, and it would not infringe anyone's exclusive rights, because you have to reproduce a thing that's already been created, and you have to have access to that thing in order to reproduce it. Okay, so when we're talking about what is protectable in a copyright, right? We talked about how copyright is only protectable to the extent that something is original in the work. That is called protected expression. What is protectable in a copyright is unique artistic expression, and we should remember that all this is derived from the notion that copyright is intended to prevent copying. Now, in order to prevent would-be copiers from getting around the law by making insubstantial tweaks to your design or to your artwork, the law has necessarily grown to define copying a little more broadly than exact 100% replication. In other words, this would be called substantial similarity in copyright case law. That's the concept. Substantial similarity is enough to demonstrate infringement of an author's exclusive rights. As I've said, copying protects against copying, and substantial similarity is intended only to capture insignificant or trivial differences. It is not supposed to capture distinct artistic expressions inspired by or even based on existing copyrighted or public domain works. Now, of course, copyright law is a little fuzzy on how and in what circumstances a work can be parsed apart. right? How do you determine what is protected expression? There's conflicting case law in this. There's disputes between various venues, but what is protected expression, what is not protected expression, and how you determine what protected expression is. But the legal question essentially boils down to whether the accused work copies, mind you, copies that which is protectable in the alleged or asserted copyright. This is referred to as protected expression. And that's not a slide. All right, I thought I had a slide of protected expression. This is referred to as protected expression. If the accused work adds something significant to the expression, it should properly be considered a unique artistic expression and not a copy. Okay, and this goes into this idea of derivative works, which we'll talk about more later. A derivative work, even though it is based on a copy, because it involves its own unique expression, it's a standalone, separate work of art that the holder of the original root copyright controls. Granted, now, of course, all this is highly subjective, which in terms of what is protected expression. And even if you know what the protected expression is, even if a judge says, here's what the protected expression is, whether or not two works side by side are substantially similar is highly subjective. And as I said earlier, that makes copyright cases highly unpredictable. But in general, on a high level, if two works of art evoke a distinct feeling or meaning, because feeling and meaning are very important when we're talking about artistic works, because again, they do not have a utilitarian function. Their function is to evoke feelings and have meaning, to make you feel something or think something. And so if they have a distinct feeling or meaning, it probably means they're not a copy of one another. This concept can be difficult to wrap your head around, but when you look at two works side by side in the context of trying to determine substantial similarity, case law in the United States says that you must put out of your mind all of that which is not protectable, but at the same time, also viewing the work in its entire context. Okay, so are you starting to see why copyright cases don't go to trial, right? Because you have, like I said, you have to, on the one hand, remove protected expression remove what is not protected in order to understand what the protected expression is, but you can't actually take the work and slice it apart into different pieces. You can't only listen to one part of a song or watch one scene of a movie. You have to watch the whole thing. You have to view the whole thing in its entire context in order to establish infringement, and that makes copyright law very very subjective and difficult to deal with when it comes to being a fact finder. And I'll explain a little bit more about how that works, but for now, I think it's been long enough. We can probably take a break, a 5-minute break right now, and then we can jump right back in and start talking about the nitty gritty of what is protected expression and how you determine substantial similarity. Okay, it is 1:46, so hopefully everybody is back. Go ahead and wait a little bit. All right, so we were talking before the break about what is protected expression and how copyright cases are subjective because the various interpretations of copyright law that come down in case law, and there's a bunch of different cases that deal with this. Some of them are conflicting, some of them are competing, and different venues have different rules about it. But in basic, the problem with determining copyright infringement, determining what is the scope of your copyright and has somebody infringed on your exclusive rights, the problem is in understanding that copyright only protects unique expression, so only what's unique to you and not what somebody else has done, and also not protecting the intangible realm of ideas. Okay, so you have to understand all that. You have to understand what is an idea, what's not an idea, what you've done that's unique compared to what other people have done in the past. But you also have to view the work in its entire context. You have to view the whole picture, the whole painting, the whole sculpture, watch the whole movie, listen to the whole song. You can't just slice parts out of it. So it makes it a very difficult determination to make. But let's go ahead and take a look at one sort of hypothetical comparison, looking for substantial similarity. Okay, so I have these two paintings of robins here. Now, consider that you have two expressions of a natural subject. Here we have two robins. Or you could also think about it in terms of a landscape. Here I have two paintings of a robin that I found using a Google image search. In the next webinar, we will discuss how and why Google displaying those images does not actually count as infringement, even though it really should. When we talk about digital works and the various issues that are related specifically to digital works. But for now, we'll just take a look at the paintings and we'll assume that this is some kind of fair use or that no one's going to come after me about this. So anyhow, we have these two paintings of these birds. When you compare one painting of a robin to another painting of a robin, what copyright law says is that you cannot say that the two are substantially similar because they both depict a robin, even if they depict the same living bird. Now, I have no idea whether or not these two paintings depict the same living bird. They probably don't. But even if the paintings both depict the same living bird, the subject matter is not protectable, right? So you can't protect that bird, okay? And if we're both painting the same bird, or even the same species of bird, here a robin, which is probably not based on the same actual living bird, they're going to be similar in a lot of ways, okay? So the concept, likewise, of painting a robin is also not protectable. So that's not part of your exclusive rights as a copyright holder. Therefore, a fact finder, meaning the jury, if there's a jury trial, is obligated to discount these similarities when making a determination about whether the two works are substantially similar. So you can think about how many paintings or photographs or drawings or written descriptions of the Grand Canyon, of Mount Everest, or Donald Trump are strikingly similar. Many of them will necessarily be so, but it's important to understand when it comes to copyright law that striking similarity is not substantial similarity. So in my view, to my eyes, these two paintings of a robin look strikingly similar. But the exercise that a fact finder has to engage in when, let's say the artist who painted the robin on the right has accused the artist who painted the robin on the left of infringement. And so you'd have to take the two works, as I've done here, and compare them side by side and say, and make a determination about whether or not they're substantially similar. Okay. And in doing that, I have to discount the fact that that they're similar because they're both robins, that they're similar because the concept of painting a robin is going to naturally, lead to the way the bird looks, the way the bird's positioned, because robins behave in a certain way. They tend to perch from branches in this way. They puff themselves up when it's cold. So the similarities, the striking similarities between these two works of art have to be discounted. And when you discount those, I would hope that looking at these two, you'd say those are two very different pieces of artwork. Those are two very different expressions of this idea of painting a robin. They have some things that are similar. They have a similar composition. The birds are both on branches. They're both looking in the same sort of way. The colors are roughly similar, but again, the colors have a lot to do with the bird, but they're both on a blue background with a little bit of white mixed in. So there's a lot of things that are similar about them. But if I was a juror and this was a trial, I'd have to say that those two things are not substantially similar, despite the fact that they are strikingly similar for reasons that are carved out of copyright protection. And again, because this is a painting of a robin, and your painting of the scope of your copyright is what is original to what you have done compared to everything else, you also have to take into consideration every other painting of a robin that's ever existed, or even every other painting of a bird. So how is the painting on the right hand side, how is that unique compared to everything else that's ever existed, right? So in many ways, copyright can be viewed pretty narrowly, and that's important with respect to the application of the law, because copyright wants to foster artistic expression, foster the creation of new works of art. Another example of this concept in copyright law that we won't go too deeply into, but just so you know, there's lots of different expressions of this concept, is a scenes à faire doctrine, which essentially means a scene that must be done. One cannot, for example, accuse two femme fatale characters in a film noir, or in two different film noirs, to be similar because they're both mysterious, seductive women whose charms ensnare the main character and lead him into dangerous and deadly situations. Those elements are what's considered to be indispensable from the film, or would be considered to be indispensable from the film noir genre. And so therefore extending exclusive protection to those elements would inhibit artistic expression by meaning that I can't now make a film noir because I'm not allowed to have a femme fatale character because one artist made a movie or wrote a book about, get rid of that, about a femme fatale character. So just think, for example, how many stories of boy wizards that existed before J.K. Rowling wrote Harry Potter and the Sorcerer's Stone. More than a few fans, for example, have pointed out that there are striking similarities between Harry Potter as a character and Neil Gaiman's character, Tim Hunter, who is a young, white, bespectacled British boy wizard who has a pet white owl. Of course, Neil Gaiman himself has appropriately described the accusations of theft as inherently silly, and he said that both he and Rowling were stealing from T.H. White anyway, right? Because art is about working from the work of others, but building on what others have done in the same way that the patent system or patent protections are about building on technology. So when I get a patent, what I'm doing is I'm teaching the world how to make and use my invention. I'm disclosing it to the public so that I get an exclusive right to it so that I can monetize it. But because I've disclosed it, now others can build on it. Now, when it comes to copyright law, disclosure is inherent sort of in a copyright because the work is only valuable if I show it, right? If I display it or distribute it, whatnot. Copyright law protects against, helps build upon the work of other artists by allowing copyrights to expire and by keeping copyrights focused on original expression and not what somebody else has done, and also making sure that copyright doesn't protect ideas and concepts and discoveries. All right, so we're talking about substantial similarity. I've gone a little bit ahead of myself in the slide deck, but the main consideration when it comes to substantial similarity is, does the overall work have a distinct look and feel, right? So if you look at these robins, I think they both have a distinct look and feel when you discount what is not part of the protected expression. If two works have a distinct look and feel, that really should be enough for a finding of no substantial similarity. Now, if the accused work has a similar look and feel, that itself does not equate to substantial similarity. And it is for this reason that the layperson is specifically not what case law would call an ordinary observer. So there's this concept of the ordinary observer in copyright law. In spite of how counterintuitive that may sound, so in spite of how you say, well, the term is ordinary observer, but aren't I an ordinary person? Shouldn't I be an ordinary observer? The problem is that in the context of case law in the United States, an ordinary observer is in fact what in the Atari v. Phillips case was come to be described as a more discerning observer. Okay, an ordinary observer is just looking at the two works side by side, right, in their entire context. But an ordinary observer is cognizant when they're looking at those two works of what is and is not protected expression. And so I like Bill Patry's blog, Patry on Copyright, and Bill Patry has I think a good quote on what is and is not substantial similarity. He's a lot more concise than I am. And Bill Patry says, for example, substantial similarity is merely a metaphor for the legal conclusion that plaintiff wins because defendant took too much protectable stuff. And that's really it, right? Because the concept is designed to prevent would-be infringers from getting around the law by making insubstantial changes to a work of art. Okay, so as weird and complicated as all this may seem, it all goes back to the purpose of copyright law, which is to promote artistic expression. Protecting one work of art should not prevent other artists from creating and protecting original works that do not yet exist. Nor can protecting a new work of authorship remove anything from the public domain which is available for anybody to use. That's also an important consideration, right? If I create a new work of authorship, fixed in a tangible medium of expression, that work of authorship should not give me control over anything in the public domain that should be freely available for everybody in the world to use. All right, so now that we understand a little bit more about copyright law and how it works and what defines a copyright, we have a basis to take a look at the second exclusive right of a copyright holder, which is the preparation of derivative works. So let's now turn to the concept of derivative works. What is it? A derivative work is defined specifically in Title 17 in the definition section. So let's take a look at what the definition says. Over here it says, a derivative work is a work based upon one or more pre-existing works, such as a translation, musical arrangement, dramatization, fictionalization, motion picture version, sound recording, art reproduction, abridgment, condensation, or any other form, and this is important, any other form in which a work may be recast, transformed, or adapted. A work consisting of editorial revisions, annotations, elaborations, and other modifications, which as a whole represent an original work of authorship, is also a derivative work. Right, so that's the definition. That is the basis of our case law here in the United States. In short, a derivative work is a separate and independently copyrightable work that is itself, in part, a copy of one or more root works. So the simplest example of the concept of a derivative work is right here in the definition. I think the simplest example is a translation of a novel from the language in which it was originally composed, which is how it would have been fixed in a tangible medium of expression. So if I write a novel in English and I publish it, it's fixed in a tangible medium of expression. If that novel is then translated into French, okay, it has been transformed from English into French. Okay. A derivative work must recast, transform, or adapt the root work, meaning that you start with the root work and then change it, literally. Thus, an author controls derivative works because they essentially reproduce in exactness some fundamental essence of the root work. In the case of a translation, which we're talking about, the language is different, but the story of the novel is the same. And the translation itself started with the entirety of the original expression. Right? That's the tightest example, I think, of a derivative work, because you take the entirety of the work as a whole, you start with it, and your intention is to create is to transform it into another language so it's accessible to readers. But you don't want to change. In a translation, you're trying to maintain as closely as possible the artistry of the original piece. Right? That's the whole point. Now, making a translation is a creative act. One of my favorite books is a translation of some Islamic text, and there's a lot of different translations of some of these works, and you can easily compare one to another and say that one is better, one is another. I like one better. I think one is more meaningful to me. I think one is closer to the original. So it is a creative act to make a translation, and that's why, because as the law would say, it is minimally creative, because a copyright only has to be minimally creative. But as long as it is minimally creative, it should be a separate copyright that stands on its own. What defines a derivative work is that it is a minimally creative work of art that is based on an independently protectable root work. Similarly, an abridgment starts with the expression, the novel, in its entirety and removes parts of it that, importantly, are not essential elements of the core narrative. So if you're abridging Moby Dick, for example, you're removing all the crap about like how whaling works, and they're going from this place to that place, what they bought, what's in the ship, removing all that stuff that that isn't related to the most important parts of what gives the work value and meaning, right? The way it creates an emotional response in the reader, right? The narrative structure of it. You're preserving all that. That's how an abridgment works. You're removing the stuff that's not important and condensing it down to make it more accessible to readers. And again, this means this all goes back to being able to allow authors and artists to monetize their expressions, their works of art. Being able to control a translation of your work into another language means it makes it easier to sell it, makes it more accessible to the public. Importantly, however, the concept of a derivative work should not be a shortcut around substantial similarity. Oftentimes, in a lot of the cases that I work, it's a plaintiff will often say, yeah, it's derivative though. If they can't make a case for substantial similarity, they say, yeah, but it's derivative. So, you can tell that it's related in some way. You were inspired by what I did, right? You looked at my painting of a robin, you said, hey, right? You looked at my painting of a robin, you said, oh, that looks good. I like the composition there. I'll use a similar composition, right? That the concept of a derivative work is in fact more narrow than a copy, because it has to start as a copy and then add something more, do something else. And so, for example, a compilation is considered to be a derivative work for the same reasons. I didn't make the songs in my mixtape, but it was a creative effort to select and arrange them, right? And the law recognizes that was minimally creative, but it does not give me control over someone else's work. I don't now own your song because I put it in a playlist, right? That's the idea behind a derivative work. You want to make sure that artists don't lose control over their art just because it has been transformed or adapted in a way that makes it more acceptable and easier to monetize. And Bill Patry also has something to say about derivative works. What he says is what makes a derivative work is the contribution of changes in the actual authorship of the pre-existing work, not a mere depiction of that work. What he's talking about specifically in this context is like a photograph of a work of art, right? It's you're not simply depicting the work, recreating it as closely as you can. There is a new creative element added to it, but it starts with a copy of the root work, and therefore it should be controlled by the holder of the original copyright. All right, so lastly here, in a little bit of time we have left, I'm going to talk about what everybody probably wants to talk about, which is the concept of copyright fair use. I think it's probably of most interest to folks in library science. Copyright fair use is very important. It's a very fundamental part of copyright law, and what it does is it essentially carves out from infringement a bunch of things that we say are good for society, right? Because the point of copyright law is to benefit society. We want to benefit our society by encouraging the creation of new works of art and allowing and incentivizing artists to do that. But we also don't want to harm our society, right? We don't want to see our society harmed because of the application of copyright law. So fair use is intended to preserve those things, or to allow those things which would otherwise be considered an infringement of the exclusive rights of a copyright holder, to allow them to happen because it serves a useful function or a benefit to society. So let's take a look at how Title 17 describes fair use. Again, it's very wordy because it's a law, but it says, notwithstanding the provisions of Section 106 and 106A, the fair use of a copyrighted work, including such use by reproduction in copies or phonorecords, or by any other means specified by that section, for purposes such as criticism, comment, news reporting, teaching, including multiple copies for classroom use, scholarship, or research, is not an infringement of copyright. In determining whether the use made of a work in any particular case is fair use, the factors to be considered shall include, and these are important, we'll talk about these in detail. Number one, the purpose, and character of the use, including whether the use is of a commercial nature or is for nonprofit educational purposes. Obviously, we want to protect nonprofit educational purposes because it's important for our society, right? We want to be able to allow teachers to do what they need to do. We want to allow scholars to be able to comment and criticize the work of others. And so nonprofit educational uses are carved out of infringement. Number two, the nature of the copyrighted work, and we'll discuss what that actually means in a little bit. Three, the amount and substantiality of the portion used in relation to the copyrighted work as a whole. And number four, the effect of the use upon the potential market for or value of the copyrighted work. Again, we've been talking, the copyright law comes down to money. It really just come down to money. We want to protect artists' ability to make money off their works of art so that they are incentivized to keep doing it, right? They're not making art necessarily for, we don't expect people to do things just for the sake of doing it. They might, but in order to encourage more of it, we want to make it profitable. We want to make it so that artists can make a living doing what they're doing, so they have an incentive to do it. So in considering whether a use is fair, it's very important to consider the effect upon the potential market for or value of the root work. Because if what I'm doing is destroying the value of your work, it's undermining the entire purpose of copyright law. The fact that a work is unpublished shall not itself bar a finding of fair use if such finding is made upon consideration of all the above factors. Okay, so that is how the code describes fair use. Now, before we dig into what those four factors mean in more specific detail, I think it's worthwhile just taking a look at some examples of what is generally considered in the law to be considered fair use. Under the fair use defense, another author may make limited use of the original author's work, importantly, without asking for permission. So if my use is fair, I don't need to ask your permission. I can just do it. It's carved out of liability. Pursuant to 17-107, which we just read here, certain uses of copyrighted material are allowable. And as a matter of policy, fair use is based on the belief that the public is entitled to freely use portions of copyrighted materials for purposes of commentary and criticism, which is specifically outlined here in the code itself. The fair use privilege is perhaps the most significant limitation of the copyright owner's exclusive rights, because again, if my use is fair, I can do it. I don't have to ask you permission. I can just do it. All right. It's a very powerful carve out. It's also powerful because you don't get to fair use until you already have a finding of infringement. Right. So let's say I'm accused of copyright infringement. If I assert a fair use defense, right, my fair use defense is moot if I don't infringe. So if my work of art is considered to be not substantially similar to your work of art, it doesn't matter, it doesn't need to be fair, right? So before you even get to fair use, you have to have a finding of infringement. And then having found that the two works are the same, are substantially similar, or is in some way an infringement of the exclusive rights of the copyright holder, then you can decide whether that's allowable anyway. Right, which means it's very powerful. It's a very powerful carve out from copyright law. So let's talk about uses that are normally considered to be fair. The following uses we're gonna talk about are normally considered to be fair, have been in the past considered to be fair uses in courts, and are kind of low hanging fruit as far as what is considered fair use. So typical cases. Criticism and commentary, pretty easy because it's right there in the written code. It calls out criticism and commentary specifically. For example, quoting or excerpting a work in a review or criticism for purposes of illustration or comment would normally be considered fair use. So if you want to talk about an example, a book reviewer would be permitted to quote passages from a book or in a newspaper column as part of an examination of the book. News reporting, summarizing an address or article with brief quotations in a news report typically constitutes fair use. A journalist would be permitted to quote from a political politician's speech without attributing it. Without getting permission from the politician. Research and scholarship, quoting a short passage in a scholarly, scientific, or technical work for illustration or clarification of the author's observations is normally deemed acceptable. An art historian, for example, would be able to use the image of a painting in an academic article that analyzes the painting. And so my use of the Robbins here is for academic purposes. Now it is for profit. Again, we'll talk about the fair use factors and what they mean and how you weigh the fair use factors, because I'm getting paid to do this, right? So I'm using it for a for-profit educational use. Okay, for-profit but educational. Non-profit educational uses are much easier to carve out of infringement. When teachers, for example, photocopy limited portions of written works for classroom use, it's normally considered to be acceptable, and it's talked about in the code itself. So, for example, an English teacher would be permitted, usually, to copy a few pages from a book to show to the class as part of a lesson plan. But here you should also note that the teacher would not be able to copy the entire book. She can't just hand out copies of the book for the students to read. It has to be the amount in substantiality is one of those factors, and that's considered. And if the amount in substantiality is the entirety, that will tend to weigh against the finding of fair use, right? The question there, and we'll get to it in a second, the question there is mostly, did you need to take all that? So as part of your lesson plan, did you need to give them the entire book, or could you have done your lesson plan with a smaller portion, right? All right, parody. Parody is an important carve out in fair use. Parody is a work that ridicules another, usually well-known work by imitating it in a common way. The more arcane description of parody that's more applicable to case law is when you're making a comment on the source, right? So a parody is specifically commenting on the thing you are using. So if I'm copying something, I need to be using it to make fun of that thing, not copying one thing to make fun of a third thing. I need to be copying something to make fun of that specific thing. Because the idea again is, did I have to use your painting to make fun of that politician, right? Was my use of that painting indispensable from my parody, right? If I'm commenting on the thing itself, it is per se indispensable, right? So because I'm making fun of the thing. Okay, so let's take a look at the fair use factors real quickly before we go to some questions here. So fair use factor number 1, the purpose and character of the use. The shorthand is, are you creating something new or are you just copying, right? The purpose and character of your intended use of the material involved is often considered the single most important factor in determining whether a use is fair under copyright law. The question here that you want to ask is whether you are merely copying someone else's work verbatim, or are you instead using it to create a new work of art? A related question in the purpose and character is whether your use is for profit or non-profit use. Now, technically, these fair use factors, we should say at the top here, technically these fair use factors have to be considered all together. So you have to consider all 4 factors all at the same time, and no single factor is dispositive of the others. So you can't say, oh, well, the purpose and character of the use is for profit. That means none of the other factors matter because it's a for-profit work. That's enough to say it's not fair use. All factors matter. All factors have to be considered at the same time. However, in practice, if it's for profit, it is almost never considered to be fair use. That said, one of the cases I was involved in did involve a successful assertion of copyright fair use with a finding in front of a jury for works that were purely for commercial purposes. Right, so you can indeed have a finding of fair use even if the purpose and character of the use is for profit. And for example of why, we'll take a look at the other fair use factors. Okay, so even if my work is for profit, as we argued in this case I was in, let's take a look at the other 4 factors. Let's take a look at the nature of the copyrighted work. In short, are you taking something factual or are you taking something creative? Okay, a court will look to whether the material you have used is factual, creative, and whether it is published or unpublished. Although nonfiction works such as biographies and news articles are protected by copyright law because it involves creative expression to make them, their factual nature means that you can rely more heavily on these works and still get protection of fair use. In short, you can't stop me from using a fact because the subject matter is not protected by copyright, right? So I can paint a robin. You can't stop me from painting a robin, right? If you write about the habits of a robin, if you write a bunch of facts, the exact words you've used to describe those facts is protected, but you can't stop anybody else from conveying that factual information. So if it's factual, it weighs against the finding, it weighs in favor of a finding of fair use. And if you're copying something that's entirely creative, it weighs more against the finding of fair use. Number 3, amount and substantiality. So in other words, are you taking too much? Or importantly, are you taking the most important parts? Now, we talked about this a little bit with respect to our English teacher. Do you need to copy the entire book? Do you need to just hand out copies of The Hobbit to your students? Or can you quote sections from the book in order to do your lesson plan? But more interestingly to me is the idea of whether you're taking the most important parts. Because even if the work is 500,000 words and you only take 200 words, if those 200 words are really, really, really important and really critical to the meaning or the value, importantly, the value of the work, that might be considered to be a substantial portion taken. And there's an interesting case that we won't need to go into very detailed because we're almost out of time. But there's an interesting case about a biography of a politician. I forget who it was, but the work was really long, and the section that was quoted in a news article was basically like the beefy revelation was the juicy bits, and so court found that because they disclosed the juicy bits, nobody wanted to read the big novel anymore, or the big biography, and so it was considered to be not protectable. Lastly, is the effect upon the market. Now here again, like I said, copyright goes back to the ability of an artist to make money. So are you competing with the source you're copying from? And this was a big factor in that case I was telling you about, where the nature of the work was commercial. The nature of the accused works were entirely commercial. They were accessories for a toy soldier. So you have a toy soldier, and I make a gun that fits in the toy soldier's hands, and it's designed specifically to fit in that toy soldier's hands. Or I design like a piece of his uniform that you're able to swap out. Like I take a shoulder pad off, and I buy your shoulder pad and I put it on. Right. I'm selling those things purely to make money. I'm not doing it just to be creative. I'm selling them to the public. I'm making money off them, but their sale actually increases the value of your product. It doesn't decrease the value. Your product is more valuable to consumers now because I now have a product in comparison to my competitors that has an aftermarket accessory. So that's one of the things we argued in that case. So the idea here is, are you hampering the artist's ability to make money off the work? And if you're not, it weighs in favor of a finding of fair use. So there's some interesting cases about infringements that ultimately were considered to have been a form of free advertising for the plaintiff, and because they were viewed as enhancing the value or providing additional value to the root work, that factor was weighed in favor of fair use. And that's it. So I think we can open up to questions now. I can drop this screen share. I'm happy to answer any questions anybody has about anything we talked about. Oh, wait, we're gonna use the chat function here, right? So nobody's gonna be on.
Oh, actually, it shouldn't be in the chat function. That's a typo. It should be in the Q&A forum. And there actually is one there already.
So how do I do this?
I'll just read it.
Okay.
What if I want to use a picture of a book that is over 100 years old and also in my library's collection that I found on the institution's website? Is it the picture that is being protected, or the book? Would I have to get their permission to use it in my library's exhibit? Is it just courtesy to credit them under the photo, or is it mandatory?
All right, so we're talking about a picture in a book that's over 100 years old. That's going to put it.
This would be a picture of a book. So I think more like if somebody took a picture of.
Gotcha. Yes. Okay. I get it. Yes. Yes. So the book itself is over 100 years old and therefore is in the public domain. But it's a photograph of that book, which is
Yeah.
presumably protected, because photographs are protected by copyright. Is your use of that photo would that use be infringing? Again, I'm not a lawyer, so it's not legal advice. But the answer would be probably yeah. I would be concerned about infringement in that case. You want to be taking a look at the fair use factors. It's probably fair use if it's academic in nature, and you credit the source. So crediting the source is always a good idea. Normally technically with fair use, you don't need to credit the source, right? Because it doesn't matter if I get your permission, if my use is fair, it's just fair, right? But crediting the source tends to weigh in favor of a finding of fair use, even though it's not really part of one of the four factors. I would kind of put it into the realm of the purpose and character of the use, right? So if your use is for academic purposes, you're crediting the source. The amount and substantiality is going to weigh against a finding of fair use because you're using the entirety of the photograph, right? But then another important factor to consider would be what effect it has on the market for the work. So if it is for nonprofit educational use, you've credited the source, and you're not interrupting the photographer's ability to make money from that photo, you're probably okay. You're probably within the realm of fair use. But that does mean you probably infringe the exclusive rights of the copyright holder of the photographer. So that'd be my sort of like gut reaction to that set of facts.
Next question.
Oh, so hang on. So one other thought. The reason why the British Library quote I mentioned or I used said that they were putting those images into the public domain, that's because those digitizations, those photographs and digitized copies could be considered independently copyrightable works, and they've injected those into the public domain. Not really, because the scope of protection would be very narrow, right? But a photograph of a work or digital copy of a work that is in the public domain is itself potentially protectable on its own.
Next question here. If a book has only one copy for purchase and 10 students need to purchase it, am I allowed to digitize it behind a firewall and host it for the semester, since students would not be able to purchase it? And in this case, it's a book from the 1990s. So I'm assuming here that we're talking about an out of print book.
Yeah, if it's out of print, it probably means the copyright is lapsed. So I would try. I mean, the answer would be no. You really shouldn't be doing that. Not to say that in this context it's not okay, but like just the idea of a teacher copying the entirety of a book and making it available, or digitizing the entirety of a book and making it available to students, even behind a firewall. That would be an infringement of the exclusive rights of the copyright holder. Now, does that copyright still exist? Has it lapsed? Has it been renewed? I don't know. So that work itself might not be protected by copyright. And on a less legal, less technical, and a more practical basis, it could be that the author's not going to come after you anyway because they don't care. It's not important enough, so you can kind of get away with infringement. But one thing I didn't talk about, because I thought people would probably have a better handle on it, and it's a little bit complicated and involved, was the limitations on the exclusive rights of copyright holders related to archives and libraries. Archives and libraries are allowed to create digital copies of materials and are allowed to distribute copies of materials. That said, it's usually required to be limited, which is why when I use my library apps to listen to books, I have to check the book out, even though it's a digital copy, because they have to restrict access according to Title 17. They can't just make a bunch of copies and distribute it. So what you're talking about is distributing a bunch of copies. Now, that said, in terms of damages, how many times you distribute a copy is immaterial when it comes to damages, right? So if you copied a book and put it online and 100,000 people downloaded it, you would not be penalized for every instance of download, because damages are related to per act of infringement, and the act of infringement is by work, not by copies. So you're only infringing one work. If the work isn't registered, right? If the copyright for that work is not registered, and you can check its registration, it's publicly available, then that means the author is not entitled to statutory damages. Okay, so if a copyright is registered with the United States Copyright Office, it gives you a presumption of validity that the copyright is valid. It's not a guarantee, but it's a presumption. And then it also means that you are entitled to statutory damages, which means that there's a stated amount that you can collect for every act of infringement, which ranges from $150 to $150,000 at the discretion of the court. So what the judge thinks is fair. But if it's not registered, there shouldn't be access to statutory damages. What are the other damages models? The other damages models are lost profits, right? So your infringement has caused me to lose money, right? So I've lost sales of my book because you distributed it. I can demonstrate that my sales are off based on X amount. You have to pay me that back. The other idea is disgorgement of profits. So you pay me all the profits you made off of selling or distributing that work. Now, again, this is one of those things I talked about in the beginning of this webinar about why copyright cases don't go to trial. In this instance, it seems like even if the work is copyrighted, even if the author cares about this, and even if that author wants to hire a lawyer and wants to come after you, right? There's no money, right? Because you're not really making any money off it. You're not selling this to students. They're not buying it from you. So what's the point, right? You would get the most you would be able to do is get equitable relief, take it down, stop hosting it, right? So on a practical basis, you're probably not going to get in any real trouble, but it is technically again an infringement of the exclusive rights of that copyright holder. The simplest thing to do, I think, in that case, would be to try to track down the author and see if you can get permission for it. But there's an interesting aspect of the carve-outs for liability with respect to an archive. And because you mentioned that that the work is inaccessible, there is a carve-out in the statute that talks about the limited availability of a work. So an archive or collection or library is entitled to make more copies of a work or distribute them more widely, I think, if the work in question, there's only one copy available of the work in question. So availability and accessibility is something that archives and libraries are supposed to be able to provide, and you don't want a single copy of a work to get damaged irrevocably. And so there are some carve-outs for that. So this might fall in that realm, but on a higher level, I think we're talking about an academic use, which means it weighs in favor of copyright fair use. It's not for profit. So the purpose and character of the use is not to make money. It doesn't seem like it would have an effect upon the market of the book if the book isn't for sale anywhere. So, and you put it behind a firewall to limit access to it. So you're probably infringing, but it's probably not a big deal. But you should get permission if you can, I would say.
And final question. Are you aware of the current lawsuit from publishers against the Internet Archive? And if you are, what are your thoughts on it?
No, I am not aware of that.
I'm also not aware of it, but I have a feeling it's probably going to run into the same sort of issues as the old Google Books project.
Internet Archive lawsuit. Here it is. Pretty recent lawsuit over online book lending could bankrupt Internet Archive. Oof. Yeah, I'm not aware of it. I haven't heard of it. There is one of the things I'm going to talk about in the next webinar is there's an interesting case about Google's digital, like Google Books, when Google's been digitizing like every book they can get their hands on. And there are a couple cases about that have come down that I'm going to talk more about in the digital works webinar, because it feels to me that it's more related to digital works. Digitizing at work is a big issue nowadays, and that seems like it's going on here. in this Internet Archive case too. But the short answer is no, I don't know anything about it, haven't heard about it, and I will look into it. And if it's relevant to the next webinar, I will talk about it.
Well, that is an excellent segue. How about a nice round of virtual applause for Mr. Green? And so, if nothing else, I will give claps. Thank you all for joining the webinar. A link to the video recording of the webinar will be emailed to you soon. You will also receive a link to provide feedback about this webinar and the series as a whole. You can use the QR code here or in the chat box. Please do take a few minutes to complete the survey. It provides us with valuable information. Our next webinar, as he just told us, is going to be part 2, looking at copyright.
Google, a lot of Google.
Yeah, copyright for digital materials.
Google gets sued a lot.
And that'll be on February 27th of next year in 2021 at 1 p.m. as well. Thank you for attending and have a good rest of your 2020, if you will, and we'll see you next year. Oh, is there something in the chat? Oh, just the feedback survey.